We turn to the fifth case on this morning's docket. It is case number 103399, State of Kansas v. Kelvin Phillips, Jr.
Morning, Chief Justice. I would request 3 minutes for rebuttal.
3 minutes is granted.
Additionally, we're going to stand on the brief as to issue 3. I want to address my remarks as to issues 1 and 2. I find myself in the unenviable position of being not only last, but somewhat redundant. So I'm going to try to act like I'm not redundant in discussing some of these issues. But the one issue that has not been brought up before in this contiguous set of arguments in the same case is the failure of the court to declare a mistrial. Firstly, there's nothing on the record in this case that indicates that the trial judge ordered a mistrial or declared a mistrial. Now, in the history of mistrial cases, if you go back, the term declare is used more often than not. And the term declare also means by its common meaning to affirmatively announce when something has happened or should happen. But that was not done here. The only evidence that we have on the record and is the judge's notes. And you could argue, I would believe, that is, although of a record, certainly not the kind that you would think of as an order of mistrial or a declaration of mistrial. It simply isn't there. I don't know whether the judge simply forgot to do that or she'd been in a long trial, so it's understandable. But the fact of the matter is that there was no mistrial declared or ordered. Contrary to the statute and the statutory intent and the legislative intent. Now, if I was sitting up there, it would come to my mind that I would say, well, Mr. Wells, so what? He got another trial. But I think that ignores the fact that the statutory intent was not followed, and I think it's important to address that. The statute itself, which is KSA 223423, gives a district court, the authority, and that's the use of the word may. That may be construed as maybe not mandatory, but what I believe the statute to say is that you may order a mistrial, giving the court the authority to declare a mistrial. One of the reasons a court can call a mistrial is if the jury cannot reach a verdict, which is the case here. And then down at the bottom of the statute is the language in F2. When a mistrial is ordered, the court shall direct that the case be retained on the docket for trial and other proceedings. Well, that was never done. In effect, the court did not follow the legislative intent, which was you have to order a mistrial.
The judge didn't use that word, but didn't she, at the end, advise counsel that she wanted to talk about putting the case back on the court's calendar?
That's true, Judge, but she never said the case is mistried. We order the case mistried. Why
is that word necessary if the effect of the judge's words conveyed what was happening procedurally?
Because the legislative intent is that it has to be ordered to be a mistrial. The fact that she alludes to the fact that it's going to be placed back on the docket, I don't think is reasonable to then conclude that the district court ordered a mistrial.
And
it just wasn't done.
Do you have any obligation to raise that issue at trial? Or do you just get to say gotcha on appeal?
Well, it is true that no counsel objected to the fact that there was not an order of mistrial, but there was not much to object to at that point. I mean, she just didn't do it.
But at the start of the second trial, the opportunity would have arisen again.
Yes.
And there was no
wasn't
motion.
Done. I'm counting on the fact that this court is going to construe this statute to be strictly construed and say when the statute, the legislative intent says order a mistrial, that's exactly what the legislature intended.
But I understood the result you wanted is that the second trial then would be double jeopardy.
Yes.
And throw that out.
Yes.
But I think the implication here is there was plenty of opportunity at the commencement of the second trial to move for dismissal based on double jeopardy, and had the trial court given an opportunity to rule on that, and that wasn't done. And so why isn't regardless of your statutory argument, why isn't your consequence not preserved, the double jeopardy argument?
Well, I think what is preserved, and I understand that, and I have no answer for that. I don't know why counsel didn't do it, because it was clear from the record of the first trial that she didn't announce it, or didn't declare it, or didn't order it. But perhaps the remedy is ineffective assistance, and that may show its face at some point in the 60-1507 action. But again, we stand on the fact that the statute says you will order it or declare it, and it wasn't done. And we believe that to be a double jeopardy type of issue. Unless there are more questions on that particular issue, I'd like to turn to the misconduct. I, like a number of other counsel who have been before you this morning, I'm going to argue that the instruction on premeditation is specific. Now, it's very interesting, and I think it's an issue of statewide importance. I think the basis of the instruction on premeditation is State versus Holmes. And I'd like to point out something that no other counsel has pointed out, and that is it is true that this prosecutor in Holmes went out there contrary to instructions by the court and used the very word instant or instantaneous that the court admonished him not to use, and obviously that's egregious. And so the court reversed that. But part of the statement of premeditation was on rebuttal. When the prosecutor went into rebuttal, he told the jury, you can form premeditation in a second. And that's part of the record, and that's part of the record in the Holmes case, but they really never addressed it. So that particular second comment, and I think that's important in the context of this instruction. Holmes court never addressed it. Now, I could argue that it was included in this court's order of reversal, but there's no language that specifically addresses a second as a time frame for premeditation. And I'm going to argue, if you look at that case carefully, I think we can assume, reasonably assume, that a second is not appropriate as a time frame. This particular instruction, I think, is ultimately confusing. When you say, as the instruction does, the concept of premeditation requires more than instantaneous intentional act of taking another's life. Well, what's more? This court has reflected on that in various cases in the past. But when you say a half a second, that's it. Why is a half a second more than an instant? Arguably. Why is a half a second more? And it was a clever comment by this prosecutor. Very clever. Half a second, knowing that he's got a factual situation where the inside of that house that this killing occurred in is absolute chaos. Not only that, there's differing testimony depending on who they would believe. We didn't go over there to do anything but beat him up. I think that was Armstrong, if Armstrong is to be believed. There's the testimony of Phillips, the defendant here, who says, I didn't intend to do that. I didn't intend to kill him. There is this brawl and this fight in a very small space over a gun. And what it does, the message to the jury is, if you've got a question about when or if premeditation was formed amidst these four men, half a second, ha, got him. That's the problem with this particular instruction. And remember, the facts of this case are not a slam dunk. First of all, it was mistried once. And the confusion that was created inside that house by these people, it's not like Kelvin Phillips walked into a room, pulled out a gun, and shot J.D. There were other participants in here, and that's why the half-second statement by the prosecutor is crucial. Because if this court believes that instant is also half a second. Now, Judge Johnson, you mentioned in an earlier argument about the case where the strangle took place. But this is a different situation. This isn't one-on-one. This is a group of men who, depending on who you believe and whose testimony you believe, went over there either to beat him up or to do something to him. So there is that to consider.
Did the prosecutor ever tie that half second to the facts? Did he ever say, Phillips had more than a half second once he picked up that gun and fired one of those 5 shots?
I don't recall that, Judge. I don't think that happened, but I can stand corrected on that.
So his only factual argument really was about them having formed the intent before they entered the house?
Yes, that's correct. So it wasn't tied to that, and that's one of the problems, obviously. What is instant? What is acceptable to this court? Half a second? 1/32nd of a second? 1/64th of a second? When does it become ludicrous?
There's no suggestion here that the weapon discharged accidentally, is there?
Well, you can read that into the testimony, I suppose, but Phillips, my client, testifies, yeah, I shot him, but I didn't intend to, and in the context of what was going on at the time, Dyer jumps on Phillips' back, and there's this brawl. That's the only way to describe it. And everybody's grabbing for the gun. Armstrong is beating Dyer over the head with an ashtray. And again, it's not like you walk into a room and shoot somebody and you're the only participants in that. This is clearly a brawl. So the point I'm trying to make is that if anybody on that jury had a question about whether they had formed this conspiracy, this intent, this premeditation before they went into that room, and there's conflicting testimony, half a second just cured that. Because then, well, even if he was in the bathroom and they were struggling, half a second isn't that very long, and maybe that's when he had the premeditation come to him. I just think it's basically unfair. This, again, I think it's a statewide problem, and I'm going to submit that. This language is awkward simply because the court in Holmes, this court in Holmes, and this instruction says you can't do it in an instant.
Do what?
Form premeditation. And to your question earlier, are you forming premeditation to grab the weapon?
No, my question is, the instruction says to have thought the matter over beforehand. What is the matter? Is the matter the murderous act, or is the matter the actual killing, or what is the matter?
Well, that's where it comes, the confusing set of facts here. Because again, it's just not one-on-one. If you've got this fight and this brawl, then the reason they are going over there, there's, again, contradictory evidence as to the reason they're going over there. So, the question is a half a second mean that you finally got a hold of the gun? And in a half a second, you say to yourself, or you form the premeditation, I'm going to shoot him. The message to the jury is simply not clear. And I think it misconstrues premeditation, this instruction. How much? What is more than an instant? Is it a half second? Again, 1/64th of a second, a second, as the Holmes case reveals. It puts an unfair restriction and burden on a defendant when that kind of prosecutorial statement is allowed to stand. So that's my point.
Counsel, you're well out of time. And you'll
I'm
have
sure
some
I am,
time for
Judge.
rebuttal. Do we have any further questions of counsel before he sits down? All right, thank you.
Thank you.
May it please the court, the state appears by Jody Litvin, and I want to start with, if I can, go back to the previous argument and read where I got that plausible language. I don't know if the court will allow me to do that, but it looks like I got it from the State versus Angelo case when we're dealing with the Batson challenges, and it says the prosecutor's burden is one of production, not persuasion. Thus, the explanation does not have to be persuasive or even plausible. It need only be facially valid. So unless I misquoted that in my brief, that
Cite for that, counsel.
287 can 262.
Thanks.
So that's where I pulled that plausible language from. Moving on to the issues in this case about double jeopardy and the mistrial. I believe there was one small line in my brief that argued that we couldn't even get to this because it wasn't objected to, so I'd like to expand on that a little bit and argue that this is not preserved for this court. There was no objection to the manner in which the jury was discharged or the fact that no verdict had been reached. The district court gave the final closing instruction and then asked that the counsel stick around for some scheduling issues. Had the declaration of a mistrial or ordering of a mistrial been questioned at that point, I believe the proper steps for defense counsel to take was either to make an objection or somehow raise this to the district court to clarify, did you declare a mistrial? Are you ordering a mistrial? Because that magic language of declare a mistrial wasn't said at that time. I think all of the defense counsels understood what was going on. I think that the statute was complied with by the district court in the fact that she placed the case back on the docket for rescheduling. And also, I did note in my brief that although it's not evidence from the transcript of that hearing, in the appearance notes dockets, or in the appearance docket notes, it does state that the court ordered a mistrial, reschedule it for this time and date, and put it on for further proceedings. And those are usually typed up from the judge's handwritten notes from that day. I don't know if the handwritten notes are in the record, but I know that the typed up appearance list was in the record. So the state's argument would be that we can't reach this issue because it wasn't objected to below. And as this court also pointed out, at the beginning of the next trial would be also another time when it could have been raised, the declaration of a mistrial or the fact that the court didn't order a mistrial. And then going on to the prosecutorial misconduct claim, again, the state's position is that this is distinguishable from the Holmes case as there was evidence of deliberate and purposeful misstatement of the law there. And there was a specific holding in that case. And if the case didn't comment on his language about it could occur in a second, I don't believe it has any relevance to this case, as there was nothing said about that language. And
Let's talk about the facts. The state was alleging that Mr. Phillips pulled the trigger of the firearm while it was pointed at Mr. Dyer with the intent to kill him.
yes,
And in order to effect that act, Mr. Phillips would have to squeeze the trigger of the firearm.
yes,
And so I guess my point is that act, is that the matter we're talking about, the act of squeezing the trigger, or are we talking about when the bullet enters his body, or are we talking about when death occurs? Because by necessity, one would form the intent to kill when you point a gun and intend to shoot someone in a vital part of their body, and that would occur at some point before the person is shot. And so how do you get an instantaneous killing with a firearm if you can form the intent, the half a second or nanosecond in which you're pulling the trigger? How do you ever kill someone instantaneously, as the instruction says you cannot do, if you can form the premeditated intent to kill a half a second before the gun goes off? Do you understand what I'm saying?
I'm not sure if I'm following it.
Okay, you would agree that you cannot have an instantaneous killing fit within the definition of premeditated killing.
Yes,
How do you instantaneously kill someone? If you can form the premeditation a half a second or a nanosecond before the gun goes off, how can you ever have an instantaneous killing? What does that look like? Tell me what an instantaneous killing looks like in this instance. What would have been an instantaneous killing in this situation? Mr. Phillips instantaneously killed Mr. Dyer. What would that look like?
are we taking it within the consideration of all of the evidence that was presented here? Say we have no evidence
I'm just
of...
saying, what would it look like? How would that have occurred? What would be the facts that you would agree was an instantaneous killing?
I suppose if you just...
Okay, sure.
How much more instantaneous could this be? I think that's your question.
Right.
On the facts of this case.
Well, due to the fact that there was a struggle, there was time beforehand to think about it then. So I guess if there was no struggle and walked in and shot, that might be more instantaneous than having the actual struggle between the gun, having it...
Was the evidence that he shot pretty much as soon as he got a hold of the gun?
Yes, I believe it was once he got back in control of the gun.
Thank you.
I'm sorry, Justice Johnson.
I thought there was evidence in the trial that they had thought this matter over on the way to the house.
Yes, and I think that the focus on the half a second is not what the prosecutor wanted the jury to focus on. I think there was an abundance of evidence that showed that this had been a plan and this had been premeditated from day one after Mr. Williams had been robbed. So I think that there was other evidence that showed premeditation occurred weeks before they had thought about it. Even if we want to go from the time that they drove up to the smoke shop, they had thought about it. They were thinking about it. From the time I believe it was Mr. Kettler who pulled the gun out of the compartment in the car, they had thought about it.
But my point is, you said that a half a second before the gun discharge was not an erroneous statement of law. That's what I understood you to be saying. And my question was, how do you, if a half a second before the gun discharged would permit premeditation, what time frame would fit within the prohibition of the instruction of instantaneous does not equal premeditation?
When he's pulling the trigger, at that moment, not a half second. I don't know if there's a good way for me to answer that.
But how do you pull a trigger without, it wasn't accidental. Your brain has to tell your finger to pull the trigger. I mean, at what point in there does it become instantaneous? I'm just, conceptually, I'm having a trouble figuring out how you kill someone instantaneously if a half a second before the gun discharge, you're premeditating. You understand what my
Yes, and I think it's a very
heartburn here?
It's a very close line, and I guess the only thing that I can say is that if we rely on all of the other evidence in this case regarding premeditation, that they had thought about it beforehand.
I'm not talking about the sufficiency of the evidence. I'm talking about the legality of the prosecutor's statement in closing. I understand your argument with sufficiency of the evidence to support on other bases, but we're talking about the half a second.
I think it's still a half a second is beforehand, and I think that the instruction says no amount of time. You don't want to put it in terms of time, which he shouldn't have done, but it's still considered to be beforehand, and it is a close call there. But that's the best way I can answer that question for now. I don't know if we want to address if we even got to the 609 letter, but I would just request that this court does not take that into consideration, as it was within the 14-day time period. And that's all I have for the court.
Any further questions of counsel before she sits down? Thank you, counsel.
Thank you, Your Honors.
Mr. Wells, I showed you'd reserved 3 minutes. Did you wish to waive that or take advantage of it?
I'll waive it, Judge.
Very well. Any questions of counsel? I see none. Thank you both for your arguments this morning. The court will take this matter under advisement. At this time, the court is in recess until 9 o'clock tomorrow morning.